All right, hello and welcome to our Estate Professional Spotlight and Q&A series. My name is Nordis Forcade-Martin. I am the founder and CEO of Florida Probate Partners, a real estate team that specializes in working with probate attorneys, professional guardians, and trust officers in helping them sell the real estate assets involved in their cases. During this series, we delve into the intricacies of probate and estate planning, and we do this with the goal of educating our community by showcasing the professionals who are problem solvers in this arena. As serious as this topic is, we like to bring light to these conversations. So do expect to have some fun. Welcome to our show. And today we have the pleasure of having Alain Roman, attorney and founder of the Alain Roman law firm. And we're super excited to hear from him. Thank you so much for being here, Alain. Welcome.
Thank you, Nordis. Thank you for allowing me to be in your series podcast.
You're welcome. You're welcome. It's my pleasure. So tell us a little bit about you, Alain, before we get into some of the serious questions we're going to be asking.
Of course. Like you mentioned, I'm an attorney. I've been practicing now, I would say, since 2016, 2017. I opened up my own law firm 2019. After a year of working with other firms, I decided that this is something that I could do on my own. So having the experience that I had, I have an entrepreneurial mindset. So I decided, okay, let's go and make our own law firm. So in 2019, I had a partner before, but decided to really go out on my own in 2019. And I've been, in the law office of Alain Roman ever since.
Funny enough, that's actually when I decided to start my own business as well.
That's good. Great minds think alike.
2019 was a great year. All right, so let's get into it. Tell us more. What is Florida law when it comes to minor children obtaining an inheritance?
Yeah, so I wanted to take some time to discuss guardianships, especially as it relates to minors, because there is a misconception as to when somebody passes away, whether that's a parent or if the minor is actually involved in an accident. Parents usually think that the funds that the minor is going to get, they're going to have access to them, and they're going to be able to use them for whatever they want, or for whatever the child needs. However, guardianship law is very restrictive. Usually, the law states that if a minor receives more than $15,000, that's the magic number. If it's less than 15, the parent just gets it. They do incur of, name of the parent, then for the minor, and then the parent can actually spend the money for the benefit of them. They're supposed to spend it for the benefit of the minor, but it's less than 15, there's no issues. But when there's more than $15,000 that the minor is going to receive, then you need to open up a guardianship. And that means that it's going to be court supervision, and the court's going to get involved, especially here in Miami-Dade and a lot of other counties. They use restricted accounts, meaning that the funds of the minor goes into a restricted account, and you have to ask the court to get money from that. So that's in a nutshell, Florida guardianship law.
Got it. So this applies both to parents that just have minor children and they would like to make sure that if, God forbid, something were to happen to them, they know what will happen to their children, or if their child got, again, hoping that never happens, but if their child is in an accident and there are funds that they're getting either from a lawsuit or a settlement, that guardianship law applies to those scenarios.
That is 100% correct.
Okay.
Guardianship can be avoided in many circumstances, and this is obviously one of the reasons why I'm here, to give out some of the options in order to avoid having to open up a guardianship. But in a lot of the circumstances, it's really not, sometimes the accident, but it's actually one of the parents passing away. Child now gets a home, a property, or life insurance, money in the bank. and now the surviving parent or another family member has to deal with that money, has to deal with the court. Usually when it comes to custody, like who's going to have custody of the child, if one of the parents passes away, surviving parent is going to have custody because they're, still the biological parent. um, when all you're seeking is custody, sometimes you can go to family court, and there's a temporary custody that you can get until the child turns 18. That's probably the cheapest and the easiest route to go. But when there's money involved, you need to go to guardianship court, probate court, in order to handle those issues.
Okay, got it. So who can be the guardian for the children?
So, Florida law usually states that somebody that's blood related is gonna, has preference of appointment to become the guardian. We usually look to mom or dad, surviving parent, mom or dad. If both mom or dad are not around, then we're looking to see which parent actually has custody or somebody that's better suited to take care of the child. Because the court will look to the best interest of the child in order to appoint a guardian. And depending on how old the child is, because if you're talking about a child that's, let's say, 14, 15 years old, we can ask this child, hey, who do you want to be your guardian? And more likely than not, we're going to get a response. But other than that, the court will pick the person that's most qualified, assuming that there's a dispute of who's supposed to be the guardian. But a lot of the times, these cases are not contested, meaning that nobody, like three or four people, are not fighting to see who's going to be the guardian of the child. They're taking care of the child until he or she turns 18 years old. But usually we look for the other parent, and the other parent usually has priority. The only thing that you need to have in order to be a guardian in Florida is that you cannot have a felony. So as long as you have no felonies, you can become a guardian. Usually they would also look at your credit score, but that's not something that's definitive. That as far as like the appointment, they're not gonna just deny your appointment just because you have a low credit score, but they will definitely deny you. They will disqualify you to be a guardian if you have a felony.
Got it. Okay. For how long does the guardianship last?
So the guardianship lasts usually until age 18. For certain circumstances, you can take it all the way to age 19, but until the age 18 of the minor, you're gonna have to have this guardianship open, meaning that every year you're gonna have to file an accounting for the funds of the minor. So if the minor is 3 years old, for another 15 years, you're gonna have to deal with the court. You're gonna have to deal with an attorney. Every guardian in Florida needs to have a guardian. And he needs to have an attorney. I didn't make up the rules, so go to your
Don't kill the messenger.
legislature. Yeah, go to your legislature and try to advocate otherwise. But guess what? Most legislators are attorneys. So good luck trying to change the law. So attorneys are not cheap, especially for guardianship. It's a lot of work to be done, and the guardianship lasts until age 18. So it's this ongoing work that needs to be done all the time.
And Alain, this question may be obvious, but we have many professionals and just families that are going to be watching this, so we want to make sure that we're clear. If the legal guardian, if there is a surviving parent, and that surviving parent, by way of what you just explained, becomes the legal guardian, does the any funds that child inherited go into, do they have to go through a guardianship and become their legal guardian, or because they're already a biological parent, they don't have to go through this process and have to file accounting for the next until they turn 18?
Yeah. If it's more than $15,000, they do have to go through guardianship. If it's
Okay.
less than 15, usually the financial institution or whatever is going to allow the parent to just sign on their behalf and
Okay.
provide them the funds. But more than 15,000, you have to go through guardianship 100% of the
Okay.
time.
100% of the time, even though they're the parent. Okay.
Yeah, unless you do things to avoid having the guardianship, because there's ways to avoid doing the guardianship, and they usually involve, for example, structured settlements. If you have a minor that got into an accident, and you create a structural settlement where the structural settlement dictates that the funds are not going to be distributed maybe until the age of 18 years old, and they're going to accumulate interest and get more money during the time frame. Or there's a trust that is established through the structural settlement for the parent to be basically the acting guardian on behalf of the child, but there's going to be someone else who's going to be the trustee managing these funds. Those are usual ways to have to avoid having to open up a guardianship. The other way, of course, when somebody passes away, is to have a trust. to have a trust in, in order to avoid guardianship.
Wow. So that's really, really good information because, again, I'm sure that there's a misconception with families that if there's two parents and one parent passes away, I'm assuming that the understanding right now is, oh, parent, surviving parent will take over and will
Yeah,
manage all the funds.
yeah, and that is an issue that comes along a lot of the times, and I see it a lot, for example, with life insurance money, that parents will designate the minor, the child, as a beneficiary of the policy, which is not necessarily a bad thing, because you want your kid to get the money. But now money goes in the child is left as a beneficiary. Now the life insurance company is going to tell you, look, you need to open up a guardianship because this money is going to go in the guardianship. At that point, you're already in the hands of the courts,
Exactly.
and they're going to put all these restrictions. And guess what? The intent of guardianship is for the minor at the time to have as much funds available to him or her by the time they turn 18 years old. So the court is not looking for you to spend money, the child's money, in things that you technically are obligated to pay. Because if you look at the Florida statute, Florida law states that a parent has a legal obligation to take care of their child, meaning legal obligation to pay for their food, to pay for their education, to pay for their health. A lot of the times, what happens is one parent passes away. Now you lose the income that that parent otherwise made. So let's say the parent was making $3,000-4,000 a month, supporting the child. Now they die. The surviving parent is able to get Social Security because the child receives Social Security until they usually turn 18 years old. But the funds that they get from Social Security are not equal in amount to the income that the parent otherwise made while they were alive. So now you have a shortage. Now you have one parent taking care of this child with less income than when the other parent was alive. So that one parent is gonna be saying, I need money to take care of my child. I need this money to pay for their schooling, to pay for this, to pay for that. Guess what? You as a parent have an obligation to pay for those things.
Mm.
So there's a conflict on what the court is going to be able to approve as far as education and health
Food.
and food and all the things, compared to the trust, which is going to be more liberal. Because a trust, for
Mm.
example, is going to say you can give to the to the guardian or to somebody responsible for the child funds for the health, education, maintenance, and support, what we call HEMS, for the benefit of the child. So there's a little bit less restriction to make sure that the child's actually taken care of. Because I don't think parents want the surviving parent to be having trouble while raising their child. I
Of
think they
course.
want the child to grow up the same way as for them to grow up as if they were alive. So if
Right.
there's funds missing and now you have to go to court, and then you are at the discretion of the judge. The judge could say yes, could say no, or could say, look, I'm gonna allow this, but I'm only gonna allow a limited amount. I'm not gonna allow everything that you asking for. So you're in a conflict with the court as to what the court thinks is the best interest of the child and what you think is the best interest of the child as the parent, because a lot of the times are the parents that are asking for money to take care of the child.
But again, with proper planning, they can avoid going through
Yeah,
that.
trust me, I battle clients all the time, like, because they want the money and they need the money. It's not something that's about wanting. Sometimes it's needing the money, meaning that we show the court, look, this is a legitimate expense for the benefit of the child. The parent is actually, this is the expenses of the parent. This is how much income is coming in. It's not enough money. And the court, a lot of the times, will say, look, I'm sorry, but, you know,
That's your obligation.
that's your obligation. So
Yeah.
it's difficult. And having a trust or setting up your estate planning ahead of time, it's ideal, important. I always tell people, look, Estate planning, probate, and guardianship is all interrelated. You do your estate planning in order to avoid probate and guardianship. If you don't do your estate planning, then you're gonna end up in court, and court is always gonna be more expensive than doing the estate planning. So that's always the case.
Bottom line, yeah. So you do need, well, actually, I was going to put an assumption there, but do you need an attorney to open up a guardianship?
You do.
Okay.
The only guardianship that you can open without having an attorney is for somebody with special needs, like if they had autism or other type of special needs that are listed in the statute. It's it's called, it's a statute for developmental disabilities, and they
Okay.
list about 5 or 6 these conditions that if they manifested before age of 18, the person can apply for a guardianship without having to need a basically to
An
have an
attorney.
attorney. They're usually most of the time just appointed for the person because the minor usually doesn't have funds, but they can be appointed for both, for the person and the property. And just to give you a little bit of background, when I say the person, usually the guardian of the person is the parent, meaning that while they're minor, while they're adult, now that's why you need the guardianship. Usually, the guardianship of the person will make decisions for them, where they should reside, where they should go to school, um, medical decisions, things like that that deal with the person. The guardian of the property is the one that manages funds, open bank accounts, is able to transfer property with the court permission, but it's basically able to administer any property that the person otherwise has.
Got it. So you mentioned what the obligations of a parent are if they're a surviving parent. What can funds be used for while the child is a minor?
A lot of the times, what we usually do in order to grow the funds is tell the court, "Hey, look, court, especially now that certificates of deposit are pretty high, we can tell the court, hey, court, we want to open up a CD, a certificate of deposit. It's gonna approve a reinvestment of the funds every year, and the money can grow that way. In certain circumstances, the child can also buy a home. If the child's gonna live in the home, buying a home is just a little bit more tricky in the sense of how much money the child has. Because if you're talking about a guardianship that has $40,000 and you have a house worth $300,000, and you want to use the funds from the child to buy the home, or at least to put a down payment on the home, then the court's gonna have questions. Who's gonna pay the mortgage? Every month. What percentage interest the child's gonna have? Is it gonna be 50-50? Who's gonna deal with this property? Who's gonna pay the lights? Who's gonna pay all the expenses? Because obviously the child has no more money, other than maybe social security money that the child's getting. So, but with the right petition, the right attorney, the right explanations, it can be done. Also, maybe you have a child that's 15 years old, they need a car. Or 16 years old, they need a car. And, they want to go to school, they need to start driving because mom or dad is working too. They need to work. So one parent passed away. So obviously, you can ask for money for a car, for example, but cannot be, for example, a brand new Mercedes Benz worth $80,000 if you if you have limited amount of money in the guardianship. Now, if you have a multi-million-dollar child, maybe $80,000 car is reasonable, for the lifestyle. So it has to be something that the child needs, or a way to improve the situation of the child, but usually
Or
just
in
to,
the best interest of the
yeah, in
child,
their best
basically.
interest, but usually just for like obligations of the parent. It gets difficult. It's not that it's impossible to get approved if you show the right facts, testimony that there's not enough funds, because the court is not going to allow the child to go hungry, let's put it that way. But
Right.
you need to show that you actually have a need for the funds to be used for that, not just a want.
Got it. You mentioned guardian of the property. So can a property be sold during a guardianship?
Yeah, it works very similar to when you have a probate. You get into a contract, the guardian will get into a contract on behalf of the child. Then you have to petition the court for approval. Usually, most counties, especially Miami-Dade County, would basically get an appraisal or some other type of comparable market analysis that reflect comparable pricing, for properties that have been sold in the area in the last, year and a half. And then, submit it to the court stating that the property is being sold for market value or close as for market value as possible, depending on the offers that are being received by somebody like yourself, a fine realtor. And once you're able to show those things, then the court will likely approve it. Most of the times they take a hearing, because if you sell a property and that's the property where the child lives, you need to be able to explain to the court, hey, look, why are you selling the child's property? Where is he gonna live? Is he gonna be rented? He's gonna buy another property? Like, you don't leave the child in the streets. Let's where is he gonna live? So the courts may want to have a couple of questions. But let's say it's a second property. Definitely, let's sell it. It's use the funds for the child. Let's grow it. Or sometimes let's just petition to rent it. Because obviously it's good to have rental income, passive income, and especially if you can have it. So having a team, doing a guardianship takes a team. Especially when you have assets for the child. Having a realtor, having a financial advisor, having other people in place so that the funds can grow, the funds can be well managed. Because obviously you have to account to the court every year.
Love it. Wow, great information, Alain. And again, a lot of information that I think, unfortunately, there's a lack of out there. So we really appreciate you sharing this insight. And we are getting into the more light and fun part of the interview, where we get to ask you
I
some
like fun.
personal questions. And so, of course, Alain does not know what questions are coming up. We love to keep people on their feet, so they're not hard though. They're to
Okay.
get to know Alain on a more human level. So, Alain, what is your favorite way to spend a Sunday?
Honestly, by the time the weekend comes around, I'm so beat that I tell myself, look, on a Saturday, I'm not doing anything. Meaning I'm just gonna be home all day, just chilling in the couch, and that's it. Sundays, if the weather's good, especially now in the summer, I like to go to the beach. Maybe spend. Usually drive down to Naples, an hour away, an hour and a half. Spend the day over there. Have a relaxing day. I'm getting old, turning I think 39 this year, so
Oh, please.
I have to stay calm. Tranquilo.
Love it. So, peace and quiet, and somewhere where you can disconnect.
Definitely.
What has been the most interesting thing you've ever learned?
Isn't it? I don't know. It's difficult because I kind of learn. I like to learn a lot, especially, for example, when I opened my own law firm at the beginning. I just learned how to do marketing. I did my own website and did everything. But I think that there's always a phrase, and this is I learned from my mom. There's always a phrase that my mom used to tell me when I was little, and I think this impacted everything I do in my life. In life, you're either a hammer or you're a nail. And you pick which one you want to be. You want to be the hammer, you want to be the nail.
Love it. That answers the question about what is the best piece of advice you've ever gotten.
Yeah, there you go.
Excuse me. And the last question then, what is the kindest thing someone has ever done for you?
The kindest thing somebody ever did for me. It's so difficult because I have the worst memory in the world. I'm not an emotional person, so I don't remember every little thing that people do for me. However, I do keep every single handwritten letter that somebody has ever given me. So I have a stack of
Mm,
it. I have a stack this big of all handwritten letters that somebody has sent me. So if you give me for me, for me, it's more important to have something, a letter handwritten or postcard or whatnot, than just particular gifts, for somebody that I care about. So
that is
so I have,
awesome.
I have a stack that full of those letters at home. So, but
I'm
if
glad that
it,
my handwritten note didn't end up in the garbage. That is a
yeah.
very good thing to know.
So but as far as like every single thing, I guess my wife is great for me. So she's the best thing that ever happened to me. So
Oh,
um
and I'm
you
lucky
know
enough to know her. And you
yeah,
are one lucky
yeah.
individual.
So anything she does every day is probably answers that question.
Oh, oh my God! So Asher will get to see this, and she will have it recorded
I hope so.
so that she knows that she is one. You consider yourself one lucky person because of her. That's awesome.
I do.
Alain, Thank you so much for your time, for joining us, for sharing your expertise and your insights. I really enjoyed it, and I know our followers will too. How can our followers reach you?
Yeah, thank you for having me. You can follow me all social media, whether YouTube, Instagram, Facebook, whatever, at the handle Alain Roman Law.
Beautiful, simple enough. Thank you, Alain. We enjoyed
No,
having you, and we look forward to having you again soon.
thank you for having me.